This is Andrew, correct?
And I am reading these in the order.
I just don't know if each screenshot is in order, is what I'm saying, because they're not stamped for time. So I don't want to make that leap, but yes, at some point she does say it's to Andrew.
So she's
Yes.
questioning who's actually sending the messages.
Yes.
And Thompson says Webster isn't even here. She says, I just want to make sure. So it's not even clear who this exchange might be between.
Oh, I think it's pretty clear based upon their names. So-
But she's uncertain if it might be him sending the message.
Okay.
And Thompson goes on to say, I would never let him touch my SHIT. And she says, ha, ha, ha. Cool,
Well,
cool.
okay, so that reference to me means I'm not going to let Webster touch my girl. So that's, that's an implication again that there's something going on there.
Isn't it possible that really what she means is that Webster might have access to his phone or his computer because they're together and it could be Webster typing out the message?
But that's another interpretation, I suppose.
Then Andrew says, I'll talk to you later. And Miss Wells says, even though I'm surrounded by people who could be on my phone, Thompson says, I probably wouldn't show this conversation, ha, ha, ha. And then there's another lengthy exchange about their workout and bringing it finally, after several pages of exchanges, based on your review of the following exchanges, there's no further conversation about legal relationships or getting together or visiting camp. Is that your recollection?
That's my recollection.
Without going through all of those in between, we agree that there's nothing else that's particularly relevant. And then finally, at the end of the exchange, Thompson says, I hope Henley went well and that you will have fun at camp. It would be awesome if we could be friends in the future. Best of luck in your next couple years at SPS. It was a pleasure getting to know you. Wells says, nope, we didn't have a chance. Sorry, just got back to USA. It was great getting to know you too. Hey, maybe we'll end up at Brown someday. And Thompson says, maybe, that would be nice, ha ha ha. And that's the end of the exchange, is that correct?
Yeah, the end of the exchange occurred just after they were interviewed by police.
And there's nothing in that exchange following to indicate that there was any follow-up conversation or any contemplation or any more kidding around about what are legal relationships and what are not legal relationships. Is that correct?
Nothing else in that Facebook exchange, no.
And there's nothing to indicate that the two of them ever engaged in anything illegal, particularly that they've never engaged in sexual penetration. Is that correct?
I disagree with that.
But a reasonable person could draw that conclusion.
I disagree with that.
I'm referring again to Attorney Zaganori's interrogatory responses on page 6 at paragraph 3B in regard to a claim of failure to impeach Mr. Thompson at trial. He says that he had previously mentioned he was concerned that any implication of selective prosecution could open the door to alleged prior bad acts by Mr. Labrie. That appears to have been a trial strategy by at least Attorney Zaganori to try to prevent the introduction of prior bad acts.
That's his opinion, that it would open the door. I don't necessarily agree with that.
But are you saying that it's an unreasonable opinion?
Well, there's two separate things there. I think you're conflating two issues. Mr. Thompson could be impeached just on bias and untruthful testimony, quite frankly, contrary statements he'd made in emails and Facebook contrary to his testimony. So those exchanges coming in to impeach Mr. Thompson, I don't believe would open the door to anything. Okay? Then there's a selective prosecution issue which doesn't just relate to Mr. Thompson. It also relates to some of the other individuals where their attorneys clearly wrote letters to the police department saying that they had agreements that their clients would not be prosecuted or would not be looked at further for criminal implications. So I think it depends on what you're saying the selective prosecution is. If, were there allegations that other people had forcibly raped, forcibly done aggravated felonious sexual assaults against other students? No. Was there indication that some of these other senior salutes probably would qualify under the computer statute? Your reading of the computer statute? Yes.
But right now we're talking about the cross-examination of Mr. Thompson when he testified.
Okay.
And the implication was that he was hypocritical, or could have been hypocritical, in his testimony that he advised the defendant that it wasn't a good idea to get together with the victim that night because of her age. Is that correct? That's been suggested.
The argument is not that it's hypocritical. The argument is that this statement wasn't made.
I'm sorry, I don't understand your answer.
The argument is that Mr. Thompson never actually made that statement and that he was not testifying truthfully at trial. And then there was impeachment evidence.
The implication is that he should have been cross-examined further on what he testified to be his statement to the defendant. Isn't that correct?
Correct. And then also to explore his bias of why he made.
Let's break it down one step at a time.
Okay.
Okay?
Yep.
The implication that has been made is that you're suggesting that wasn't a truthful statement now, that he may not have made that statement. But prior to what you've just testified to, the implication has been that Mr. Thompson should have been cross-examined about his own relationship with a 15-year-old, and that it's incredible that he would advise the defendant that it wasn't a good idea because he was in a relationship potentially with a 15-year-old as well. Is that correct? That's
Right.
the implication that's been made.
Right, that it's incredible that he would say it, that he actually did not say it.
But isn't it possible that if that line of cross-examination had been pressed, that would have opened the door for Mr. Thompson to explain that he advised Mr. Labrie that it wasn't a good idea to meet up with the victim that night because he knew what the defendant's intentions were, which were different from his intentions in his own relationship with his friends at St. Paul's School? Isn't it possible that it would open the door for that type of explanation if he had been pressed on that matter on cross-examination?
Well, then I think Mr. Thompson would have been further questioned about why he'd never said that before. So I guess Mr. Thompson could have said whatever Mr. Thompson wanted to say, but if Mr. Thompson testified contrary to statements he made to the police, then he would have been further cross-examined about why he was just coming up with that then, because he'd never said that before.
It's quite possible that if pressed, that testimony could have been more damaging to the defendant rather than helpful.
I disagree.
And when Attorney Zaganori talks about being very careful not to open the door to other prior bad acts, you were aware from your review of discovery that Ms. Wells was interviewed, correct?
Correct.
And you made a point of obtaining that interview transcript, is that correct?
I saw the transcript I got after the fact. I mean, just recently I got the transcript, but I believe I had the audio or the audio video of that. I believe I had that early on.
And isn't it possible that if pressed on that line of cross-examination, that the state could have argued that defense was creating a misimpression in the minds of the jury by indicating either that Mr. Thompson had had a relationship with EW or possibly how far that relationship might have gone? Isn't it true that in EW's interview, she's asked about her relationship with Mr. Thompson and she indicates that there was nothing sexual in her relationship with Mr. Thompson? Isn't that correct?
I think she says that, yes, she says that.
And that line of cross-examination, if pursued, may have opened the door for the state to offer the interview for Ms. Wells as to what she actually did disclose. Isn't that correct?
Sure, what she said about Mr. Thompson, sure.
Sure. And to alleviate any misimpression in the minds of the jury, the state could also have argued that it opened the door to statements that Ms. Wells made in regard to the defendant. Isn't that correct?
I suppose you could argue that, but I don't think that's true.
It's possible that we could have argued it and that would have opened the door. And isn't it true that Ms. Wells not only indicated in her interview that nothing sexual happened with Mr. Thompson, however, she had an encounter with the defendant that was aggressive, that he bit her breasts in a manner that was similar to the testimony of CP at trial, and that testimony could have been more damaging to the defendant than helpful. Isn't that correct?
That's not correct. I don't agree with a lot of that statement. Ms. Wells said in her interview that she did have an encounter completely consensual, and she says it a few times, this completely consensual encounter with Mr. Labrie.
And I never suggested that it was not consensual.
Because she made a point of saying it was completely consensual.
She made a point of disclosing that in her encounter with the defendant, he bit her breasts, that she felt that was aggressive, she didn't feel that it was appropriate, and she was uncomfortable by that.
I don't think that's exactly what she said. I think that's a mischaracterization of what she said.
Isn't it correct that if that line of cross-examination had been pursued, it is possible that additional evidence could have been argued by the state to be admissible, which could have been harmful to the defendant?
If you think that 404B evidence would have been that he had a consensual encounter with another girl that was not sexual in nature, that she said was completely consensual, and that would have opened the door to it, I suppose you could have argued it, but I don't think that that's what 404B evidence says. I don't think that's what the law says.
And again, we're not talking about consent with EW versus not consensual. We're talking about the specific aggressive acts.
I suppose you could have argued it, whether or not Your Honor would have permitted it. I disagree.
Similar to your proposal that if the line of cross-examination had been pursued, that it would have been helpful to the defendant.
Differences of opinion.
Exactly. Reasonable minds can differ. Isn't that true?
Sometimes.
Let's talk about jury instructions at this point. And again, you testified that you had limited involvement in trial, but you did participate in the Chambers Conference regarding the jury instructions. Is that correct?
Yes. I don't recall what I said. I recall being there. I don't specifically recall the conference.
And you indicate that you were not asked to prepare jury instructions regarding any of the charges.
Correct. Well, prior to the email saying, "Can you review these?"
And you were not provided with the draft instructions prior to trial. Is that correct?
Correct. Prior to trial, correct.
And when you were provided with the draft instructions, it was late in the evening and it was the last minute, correct?
Correct.
And you state in your interrogatories that you recall the next morning, Attorney Carney asked me to take the lead on the conference regarding the jury instructions.
I don't think I said take the lead. I think he asked me to, I think my testimony was, I don't remember exactly, it's something like, feel free to jump in or, do what you need. If you feel like something needs to be said or something's incorrect, feel free to jump in, participate,
May I
something.
approach the witness, Your Honor?
Yes.
I'm going to give you a copy of your own interrogatory responses.
Okay.
And I would ask you to read from the beginning of this paragraph.
This one here?
Right here, I'll read it for you. I recall the next morning, Attorney Carney asked me to take the lead on the conference regarding the jury instructions.
Okay. I think I probably misspoke in my interrogatory answers because I don't
So are
think
you
he actually
stating
said
that
take
your
the lead.
interrogatory answers aren't accurate?
I think probably saying taking the lead was a little overstated.
But this was your statement that you swore to and provided.
Correct.
It says, I recall the next morning, Attorney Carney asked me to take the lead on the conference regarding the jury instructions.
Okay. I read
This took me
that.
by surprise, given that I had not been present for trial, and my involvement pre-trial had been so limited. But I did the best I could.
Mhm.
That is
Okay.
accurate?
I don't remember exactly what his words were. Maybe his words were take the lead. As I sit here today, I can't remember exactly what he said to me out in the hall. Maybe at the time I wrote those, I think he maybe said lead. I honestly don't know exactly what he said to me out in the hallway.
At any time, did you indicate to either Attorney Zaganori or Attorney Carney that you didn't feel prepared to address the issues in the Chambers conference that morning?
I assumed that they had reviewed the instructions.
Please answer my question. At any time, did you indicate to them that you were not prepared to address any issues that might come up in the Chambers conference?
I'm trying to answer your question because you're saying at any time, so I'm trying to answer the question.
Okay. Let me break it down.
Okay.
In your email exchange with Attorney Zaganori the previous evening, when he asked you if you could take a look at the jury instructions, did you indicate to him that you didn't feel prepared to review those?
He said to me, if you get a chance to review these, can you? I mean, it was a very offhanded comment, and so I didn't say anything to him because the implication in the email from Attorney Zaganori was that I was just kind of an offhanded review. Sure, I'll do that. There's no problem there.
That you were adding another set of eyes.
Exactly.
Okay. And then, you do say in your interrogatory, given my lack of knowledge of discovery, facts of the case, legal strategy, and having not been present at trial, my ability to assess the jury instructions was very lacking. Did you communicate that to Attorney Zaganori or Attorney Carney?
I think it was pretty clear to them.
Did you communicate that to them?
They knew what my role was. I didn't have to communicate to them because they instructed me what my limited role was.
You didn't communicate that to them?
Correct, because I assumed they knew I wasn't at trial because I wasn't sitting there with them.